Let me go across now to Shehzad Poonawalla for his response to the split verdict that's been delivered. Shehzad, we spoke to some ministers in the state of Karnataka. They're saying that this is not a setback. Ultimately, it's the Constitution bench that will actually have a larger bench, rather, that will have to deliberate on this matter. But your immediate response to the split verdict?
You see, look, the Supreme Court has given a split verdict and it has been referred to a larger bench. Now, as the matter stands, the Karnataka government order has been upheld by the Karnataka High Court and one judge of the Supreme Court. One judge of the Supreme Court has disagreed with the order. Therefore, the Karnataka government order and the High Court order both remain in force because there's no stay on it. Now, what we are witnessing across the world in terms of Mahsa Amini's campaign, we should be emphasizing to put Kitab above Hijab, and that's what the women across the globe are fighting, to rid themselves of symbols of patriarchy pushed in the name of religion. My mother and my sister, who studied decades ago, never wore the hijab, and that's my personal opinion. They are practicing Muslims. So therefore, it would be well advised that parties like the Congress, because I was just seeing a reaction from a Congress leader, Arif Masood, the Congress party and the PFI, the CFI, their role in stoking violence and stoking mischief has been called out by the Karnataka High Court, whose order continues to be enforced. We've seen the unseen hands engineering social unrest, and therefore the question is that at a time when the world is crusading against the symbols of patriarchy, why is Congress sacrificing women's rights at the altar of vote bank politics? So that you would remember better than most the Shah Banu to Shaira Banu, from the verdict in the Shah Banu case to the triple talaq verdict, every time the Congress, which claims to say ladki hu lad sakti hu, has sacrificed women's rights at the altar of vote bank politics, and that's unfortunate, and they should avoid doing that at this stage.
One more reaction from you, Shehzad. You're also a lawyer, so therefore Justice Dhulia, in his judgment, invoked the Bijoy Emmanuel case, where members of the Jehovah's Witness chose not to sing the national anthem, but they stood in respect, and yet their rights under Article 25 to not sing the national anthem was actually upheld by the top court, and that was now invoked by Justice Dhulia to also rationalize the wearing of the hijab on the part of the young Muslim women attending pre-university colleges, saying that they were also invoking their right under Article 25 of the Constitution. Your specific observation, also as a lawyer, someone with a legal standing, on that particular observation made by Justice Dhulia?
You see, it's not for me to comment on the view of one judge, because his brother judge in the same bench has completely disagreed and has allowed the government order to continue to remain in force, has allowed the High Court order to remain in force, and has dismissed all appeals and has answered the 11 questions that he thinks were the central issues to be tackled in this particular case. So clearly his view is not accepted by his brother judge on the bench. It is now for the larger bench to come up to a conclusion. But my view is that unless it is to be an essential religious practice, such kinds of things can't find any protection under fundamental rights or other things. And therefore, the essence is that is it an essential religious practice? And so far, the Karnataka High Court and other orders of the courts have held that hijab is not an essential religious practice, and therefore, that is the law of the land as it stands today.
Right. Many thanks for the response, Shehzad.